Hello friends, this is Saurav and this is lesson 6 of our ongoing series called Legal Research in Litigation. In this lesson, we will discuss about hierarchy of legal sources and their importance. In litigation, not every legal source carries the same weight. What matters is not just what you cite, but how and where it is applied. In practice, confusion often arises around questions like, does this authority bind the court? Is it persuasive only? Or does this authority applies to the issue being argued? So, in this lesson, we will discuss about the hierarchy of legal sources and why authority selection directly affects the strength of an argument. People often think if it is a judgment, then it must be relevant, right? But it should be remembered that different sources carry different weight depending on the context. Courts see it as a hierarchy. Every source of law carries a different level of authority, and courts instinctively weigh arguments based on where the law comes from, who decided it, and whether this binds the court. And ignoring this hierarchy often leads to weak arguments. At the top of the hierarchy are the statutes. Courts are bound by acts of parliament, state legislations, and statutory rules and notifications. If a statute clearly answers the issue, then case law becomes secondary, interpretations become limited, and arguments get short significantly. People often make this mistake that they go for judgments while they ignore the statute itself. But remember, courts will always return to the text of the law, and a good researcher always starts with the statute, not the database. Supreme Court judgments are binding under Article 141, but people often misunderstand what that means. Supreme Court judgments bind on the principle decided and within the context of the issue addressed. It does not mean that every paragraph applies to every case. The factual differences can be ignored, and procedural posture is irrelevant. So, you should remember that Supreme Court judgments carry the highest authority, but their application still depends on the issue, facts, and the stage of the case. High Court judgments operate differently. High Court decision binds courts within its jurisdiction and have persuasive value elsewhere. People often prefer citing a distant High Court's judgment over a local one directly on point. This is a mistake. Courts give greater weight to jurisdictional relevance, factual similarity, and clarity of reasoning. Remember, High Court's judgment matter most where it has jurisdiction. Elsewhere, its value depends on relevance and reasoning. Prestige never outweighs applicability. Another area people often overlook is the bench strength. A judgment by a larger bench always overrides a conflicting judgment by a smaller bench. So, ignoring this hierarchy often creates confusion, invites objections, and weakens your arguments instantly. Courts are very sensitive to this aspect. If you miss it, the court notices. Persuasive sources include judgments from other jurisdictions, coordinate bench decisions, foreign judgments, and academic articles. These sources do not bind but can always assist if used correctly. These sources should support an argument, not replace binding authority, and never contradict the settled law. Used wrongly, these sources damage credibility. When court examines the authority or the citation placed before them, certain questions naturally arise. Is the authority or the citation binding on this court? Is it persuasive? And if so, why? Is it relevant to the issues being decided by this court? So, the strongest point in your research is not about the number of cases you cite, but about the choices you make. If a weaker authority is cited upon while a stronger one exists, your research itself loses its force. That's why authority selection is not about how much you know, it's about how carefully you apply what you place before the court. Before citing any source, just ask yourself, does this bind the court? If not, why am I using it? Is there a stronger authority I am missing? Right? A hierarchy aware legal researcher uses statutes first, relies on binding judgments second, and supports with persuasive sources last. This approach immediately improves your clarity, your confidence, and your court's presence. Once you understand the authority hierarchy, another problem becomes clear. The same research approach does not work at every stage of a case. So, in the next lesson, we will discuss about how legal research changes between interim reliefs and final arguments, and why many fail to adjust their strategy. Thank you.